Good morning or good afternoon, depending on where you're joining us today. My name is Brian Lamb, and I would like to welcome you to today's Thompson Hine sponsored webinar. I will be co-presenting today with Tim McDonald, a partner in our Atlanta office, and we are joined by Stephen Penrod, a partner in our Cleveland office, who will be monitoring your questions. Today we will cover various aspects related to ERISA litigation. This webinar is the third in a series of webinars slated every Thursday at noon through the month of September. Each webinar will explore a different benefit-related topic. Please join us every week or just for the topics of interest to you. You can register for additional seminars through the invitation you received. You can also apply for CLE or HRCI credit for today's webinar. There is an attorney affirmation form in the handout section. We will give you the code you need to complete the form at the end of the webinar if you are still awake. During the webinar, please feel free to use the question panel to submit questions. We will answer questions at the end as time allows. Any questions we do not answer during our time together will be responded to via email after the webinar. So with that, let's begin. Today we're going to cover three different aspects of ERISA litigation. The burgeoning fee litigation involving claims of excessive fees in 401k and 403b plans. I'll give a quick overview of actuarial assumptions litigation that's going on right now. There's 9 bellwether cases pending around the country involving actuarial assumptions in defined benefit plans. And then in the second half, Tim will give an overview of what some are calling the year of ERISA in the Supreme Court, given the unusual number of ERISA cases the Supreme Court is slated to hear this year. So let's jump in on the fee litigation side of things. Again, this is where the fiduciaries of a 401k plan or a 403b plan are being sued for allowing the plan to pay excessive fees to third-party providers or failing to conduct RFPs on a regular basis and or stuffing the plan with expensive, poor-performing investment options. To summarize, plaintiffs' lawyers. There is a lot of this litigation going on. Cases continue to be filed every day. They also continue to settle. I'll show you some statistics on settlement. And some actually go to trial, which is unusual in this day and age for commercial type cases. It's also unusual for ERISA cases to go all the way to trial. Most get resolved at the motion to dismiss phase and or settle. The cases that have gone to trial recently include the NYU fee case and the American Century case, both of which were defense side wins. And the MIT case is scheduled to begin trial next week. So that should be an interesting one to watch. The big picture in these cases, which have been going on now for some number of years, is that the fiduciaries win sometimes and they lose sometimes. And as happened in the University of Pennsylvania's case, sometimes they do both. In the Penn case, the fiduciaries were motion to dismiss was granted by the trial court, and then on appeal, the Third Circuit reversed the granting of a motion to dismiss and sent the case back for discovery. Every once in a while, someone asks me, "Oh, I saw there was a win, or I saw there was a loss. Does that mean that there's an end in sight for these cases? That's either the plaintiff side or the defense side is going to ultimately prevail?" Depending on where you sit, sadly, the answer is no. There's definitely no end in sight. The cases keep coming, and there's so much money held in 401k plans and 403b plans. I mean, billions and billions of dollars. And there's so much uncertainty baked into ERISA as a statute that those two things combined are the raw ingredients for litigation. If you think of ERISA, the reason there's so much litigation, in my opinion, is because many of ERISA's most important rules are really standards, like reasonable or reasonableness or prudent or prudence. And prudence and reasonableness can be determined in the eye of the beholder. Fiduciaries have to take their actions without knowing for sure whether those actions would pass court scrutiny later on. Will a court think that something a fiduciary did is reasonable or prudent or not? Because you don't know until someone challenges it and the court rules. There's just lots and lots of opportunity for litigation in this area. Here are some recent settlements in the fee litigation. I've put them here. These are just a sampling, so you can see the different kinds of industries that are involved, as well as some of the eye-popping dollar amounts involved. I will say that before I turn to the next slide, I don't have a slide in here about arbitration, but I've been getting this question a lot in the past week or so. The Ninth Circuit came out with a case in which it held first that ERISA claims are subject to arbitration if there is a valid arbitration clause. In my view, this is not a controversial ruling. It was finally the Ninth Circuit catching up with every other circuit. The other circuits have held that ERISA cases are arbitrable, just like virtually every other kind of dispute out there in federal court. But what was interesting in the Ninth Circuit case, which was Dorman versus Schwab, is that the court went a step further and enforced an arbitration clause that appeared in the plan document and forced a single participant to take their fiduciary duty claim against the Schwab fiduciaries to arbitration. Again, that part's not that controversial because there was an arbitration clause in the plan documents. But what is controversial is the court also said that that participant could only bring the claim as far as their own individualized losses, that that participant could not arbitrate losses to the entire plan as a result of the challenged fiduciary conduct, but instead could only sue or arbitrate and present claims for his or her own losses. This is probably too good to be true from my perspective as a defense lawyer. It would be great if arbitration clauses like this were routinely enforced and participants could only bring claims against fiduciaries to restore losses to their own individual eligible account. But ERISA has an express statutory provision allowing participants, among others, to bring fiduciary duty claims to restore losses to the plan, not just losses to someone's individual account. This is why in all these cases you see on the screen, 1 or 2 or 5 participants brought these multi-million-dollar claims because a few people were bringing claims on behalf of the entire plan, sort of a built-in quasi-class action. So there was a victory for the defense side, a week or 2 ago in this Ninth Circuit case, but my instincts tell me that it's too good to be true and it probably won't last. So it is still too early, I think, to start baking arbitration clauses into your plans because arbitration has a number of other downsides that go with it, including the lack of an appeal. So back on the slides, probably the biggest development going on in the fee litigation is the rise of non-monetary concessions in ERISA settlements. So I just showed you a slide that had a number of eye-popping dollar amounts that were paid by the fiduciaries or their insurance companies to the plaintiffs in these cases. But more and more, the plaintiffs are insisting upon, and some defendants are agreeing to give non-monetary concessions. And, at some level, well, what could it hurt? Non-monetary concessions. We're really worried about how much money we have to pay. But once I show you what some of these non-monetary concessions are, you might share my heartburn over what some fiduciaries are agreeing to do on a going forward basis, in addition to just paying millions of dollars in settlements. So, for example, this recently came up in the Johns Hopkins 403B case where after several years of litigation, Johns Hopkins settled to pay a very large amount, $14 million, the second highest ever by a private university. But they also agreed to non-monetary settlement conditions, which will affect the way the plan is run and, in my view, will keep the plan entangled with the plaintiff's lawyers for the next 3 years. So, for example, these are from the settlement documents that were filed with the court in the case. The plan defendants agreed to a 3-year period of monitoring by the plaintiff's counsel, during which plaintiff's counsel will stay involved to monitor compliance terms and bring enforcement action if necessary. Another thing they agreed to was to provide customized annual reports to plaintiff's counsel. Again, think about it. You don't just get to cut your check on the day of settlement and move on with your life. You're now having to give reports to the lawyers who brought the suit against you in the first place. The Johns Hopkins defendants agreed to retain an independent consultant to assist the fiduciaries in looking at things like vendor windows and investment structure. That one's not as offensive. Maybe it's a good idea to have an independent consultant. But they also agreed to issue RFPs on a regular basis for record keeping and administrative services. We're going to talk about RFPs in a minute. They agreed to a prohibition on cross-selling, so that any service provider who provides services to the Johns Hopkins plan will be asked by Johns Hopkins to include a contract provision in their service provider agreement that they will not solicit current plan participants for the purpose of cross-selling proprietary non-plan products. The defendants agreed to share RFP bids with plaintiff's counsel. They agreed to communicate the results of the review and which RFPs are selected. And the defendants even agreed to consider specifically identified factors when determining investment options, including the cost of different share classes, the availability of revenue sharing rebates. In my mind, this is comes very close to the fiduciaries agreeing sort of to have their hands tied in advance by agreeing on what factors they're going to consider as part of the total mix. So to me, these are not throwaway considerations. They're not last-minute add-ons. If I recall correctly, the parties reached agreement on the $14 million figure and then negotiated for another 2 or 3 months on these non-monetary items. They were a serious and important consideration. I think the plaintiff's counsel is really pushing these as a technique in structuring their settlements of these cases going forward. Johns Hopkins is not the only example where this is happening. It's just the most recent one that caught my eye.
Wow, it keeps them.
Yes, and it keeps their nose under the tent for the next 3 years. Okay, so this begs the question, another hot topic, are RFPs required every 3 years? We get asked this question from time to time. The context here is that ERISA does not expressly require fiduciaries to issue RFPs for plan services. So, for example, if you're going to hire a record keeper or an investment provider, rather ERISA has this general standard that you must not pay more than a reasonable compensation to a service provider. So you can't look at ERISA's terms and say it requires an RFP. However, the plaintiffs in several cases have hired experts who will testify that as a practical matter, to be prudent, you must conduct an RFP every 3 years to ensure against paying above market fees. Again, this sounds awfully specific, must do it every 3 years. That's not set forth in ERISA. That's what the plaintiff's lawyers are providing as content, in their view, for what the word reasonable means in this context. And some courts are letting the plaintiffs proceed to trial in cases where the fiduciaries did not conduct RFPs every 3 years. In other words, plaintiff sues, has an expert who says you didn't do an RFP every 3 years, therefore we can go to trial to determine if the fees that you allowed the plan to pay were unreasonable. The defendant files an opposition that says there's no requirement that we do that. And the judge says, I'm going to allow this one to go to trial, and we'll see what your battle of experts says about what was reasonable in this context. So just last month, another court refused to dismiss a breach of fiduciary duty claim premised on the failure to engage in a competitive bidding process. Court said plaintiff could pursue this claim via expert testimony at trial. This was in the Western District of Kentucky, relying on the Kraft Foods case from the Seventh Circuit, where the court in the Seventh Circuit case didn't come right out and say, thou shalt have an RFP every 3 years. Rather, it said, well, plaintiffs say you need one every 3 years. You didn't do one every 3 years. Let's go to trial and we'll determine there if that was reasonable or not. So a possible takeaway from this is, although conducting an RFP is not required by the express terms of ERISA, a fiduciary who conducts one every 3 years will deprive plaintiff's counsel of one dangerous line of attack. Again, that's just one of many factors you might take into account in deciding whether it's worth the pain and expense, disruption, inconvenience of conducting RFPs and actually seriously considering changing service providers. But there's certainly is some truth to the fact that if you do it, you are giving yourself an extra layer of protection. Another hot topic going on in the fee litigation is the use of participant data for marketing purposes. So in the Northwestern case, the plaintiffs at the last minute tried to amend their complaint. They were making the usual excessive fee, crummy, expensive investment option arguments that they make in these cases. And in fending off a motion to dismiss, they asked for permission for leave to amend their complaint to beef up those existing claims, but also to add one in that the defendants, the fiduciary, should be liable for allowing the plan's record keeper to market products to plan participants using participants' contact information, their choices of investments, the asset size of their account, their employment status, age, and proximity to retirement. Again, the idea being the plaintiffs were arguing the service provider was using that information to then solicit the participant population for non-plan services. Okay, so what the court said, and this is the district court in the Northern District of Illinois, rejected plaintiff's argument and said it's not imprudent to allow the record keeper to have access to this kind of information. And actually, if you look back at the list, I mean, it's the kind of things you would expect a record keeper to have access to in order to keep records, participant information. So the court said it's not imprudent, to allow for the fiduciary to allow that, and that the disclosure of such information just does not implicate ERISA's fiduciary functions. The court noted that not a single court has held that releasing confidential information or allowing someone to use confidential information is a breach of fiduciary duty. In one quote, which the defense lawyer and me particularly enjoyed, this court will not be the first, particularly in light of Congress's hope that litigation would not discourage employers from offering plans. The court also held it's not a prohibited transaction because the court is not convinced that information like that is really a plan asset. So this case is presently on appeal to the Seventh Circuit. Oral argument was held at the end of May, so theoretically a ruling by the Seventh Circuit could come out at any time. It might address this issue. There were other issues on appeal. It might address this issue, and who knows what they'll do with it, but that is a case to keep an eye out for. A similar case on the use of participant data for cross-marketing is the Vanderbilt 403B case. There, the plaintiffs alleged, among other things, that Vanderbilt failed to protect confidential participant information from being used by one of the plan's record keepers to market a variety of financial products to the plan participants. Similar allegations to Northwestern. But in Vanderbilt, the parties settled. Okay, so in the Northwestern case, the judge issued a ruling on the question, and it was in an awkward procedural posture because the plaintiffs kind of brought the argument up late, and it could be the judge was kind of mad at them for bringing it up late, and so they had a higher standard for whether it was a suitable claim to bring. Setting that aside, the Vanderbilt case, this issue came out in the settlement posture because Vanderbilt submitted papers to the court with a proposed settlement in which they would pay $14.5 million. Again, a very large settlement amount. I think the highest for a university, a private university so far. And it agreed to make some other non-monetary concessions like we saw in Johns Hopkins, additional disclosures. We will conduct an RFP. And then the last bullet point here, the Vanderbilt agreed that the fiduciary shall contractually prohibit the record keeper from using information about plan participants acquired in the course of providing services to market or sell other products or services unrelated to the plan, unless that contact is initiated by a plan participant. Like, I know we've had discussions amongst ourselves. This raises a whole host of issues as a practical matter. Who's going to determine who initiated the contact, and what if they went to the website of the record keeper and it has lots of options or links listed there? Lots of thorny issues here. But it's still the case that no court has said that it's a breach of fiduciary duty for a fiduciary to allow a record keeper to use this kind of participant data for cross-marketing, although you will see articles and such that are decrying the practice. It's still the case that the Northwestern court said that's not a fiduciary violation, and the issue never got teed up for a court in Vanderbilt because the parties settled. And Vanderbilt agreed voluntarily that it would impose that restriction on its service providers. In my last 5 minutes here before we switch over to the Supreme Court, I'm going to touch on the actuarial assumptions litigation that is going on in 9 different courts around the country, where these involve defined benefit plans, and it involves plaintiffs, some of the same plaintiffs firms that are involved in the excessive fee litigation. They have brought 9 what I call bellwether or trial balloon cases against some very brand name companies, and the actuarial assumptions that are baked into those companies' defined benefit plans for purposes of calculating alternative forms of benefits, alternative to a single life annuity. So like joint and survivor annuities or other kinds of alternatives to a single life annuity. The backdrop here is, as the actuaries will tell you, there's 2 kinds of uncertainty baked into the actuarial assumptions used in this context, and that is the life expectancy of your participant population, and the other is the time value of money, or net present value. Again, because you're trying to figure out what's an actuarial equivalent joint and survivor benefit. How do we make that actuarially equivalent to a single life annuity? And so the plan has certain assumptions that it has to make because it's dealing with 2 unknowns: who's going to live for how long, and what's the right discount rate to use to bring money back to a present value calculation. So that's what actuaries do, and there are actuarial assumptions baked into all defined benefit plans that have alternative forms of benefits. So there are 9 cases. These are listed here in the order that they were filed starting last December. MetLife, American Airlines, Pepsi, US Bank. You can see we list the different kinds of mortality tables or assumptions being used and being challenged by the plaintiffs. So for example, with American Airlines, they're using a 1984 mortality table, and the plaintiffs argue that mortality rates have changed dramatically since 1984. Why aren't you using more current mortality tables? And you'll notice the interest rates, as we flip through these, are different plans are using different interest rates. Sometimes even, like Anheuser-Busch is using 2 different interest rates depending on which sub-plan you're a part of. So Rockwell, Anheuser-Busch, Huntington, Raytheon, Partners Healthcare, which is in Massachusetts, these are the companies that are facing this litigation right now. It's early, very early days. It's been a while since a new one was filed, so these might be the 9 test cases that we have for a while. Every defendant has filed a motion to dismiss so far, and they come up with very good and interesting arguments. And 2 courts have ruled so far, American Airlines and U.S. Bank. And in both cases, the court said there's enough here to survive a motion to dismiss. So the court denied the defendant's efforts to cut off the litigation at the motion to dismiss phase. In my view, these are just procedural rulings. It's very difficult to get a motion to dismiss granted in federal court. None of these courts have tackled the actual substantive arguments being made by the plaintiffs or the substantive defenses being made by the defense. They're just saying the procedural arguments raised by the defendants at this point don't work at the motion to dismiss phase. Here's where the cases are pending. The different colors represent the U.S. Courts of Appeals. So, for example, I'm in the 6th Circuit, which is the gray one from Michigan, Ohio, Kentucky, and Tennessee. We don't have a case filed in the 6th Circuit. The white X's represent where those 9 cases are filed. So you can see there is definitely an effort by the plaintiffs' lawyers, I think, to get geographically diverse district courts so that the bellwether cases can percolate up through different circuit courts. There's a notable absence of any filing in the 9th Circuit, which usually is considered plaintiff-friendly. But I'm not planning any ideas with the plaintiff's lawyers for that regard. So with that, I'm going to bring this part to an end. I will say that next Tuesday, if you are interested in the actuarial assumptions litigation, I'm participating in a longer 90-minute webinar that takes a deep dive in these cases. And my co-panelists will include an actual actuary who's 10 times smarter than I am and is very interesting to listen to on these issues. So if you would be interested in that webinar, you can just Google Stratford and actuarial assumptions, and you'll probably find it, or email me at brian.lam@thompsonhine.com. So with that, I am now going to mute us here in Cleveland and turn it over to Tim McDonald in Atlanta.
Thank you, Brian. Good morning or good afternoon, everybody, depending on where you are. And I'm going to speak for the next few minutes about the Supreme Court's ERISA docket. And of course, given that ERISA has a strong federal preemption bent, when we talk about the Supreme Court, we're talking only about the Supreme Court of the United States here. Many years, there are simply no cases at all that the Supreme Court hears in ERISA. They are a well-known bunch in terms of their decisions that catch the media, but oftentimes it's only ones that hit on certain hot button issues that get everybody's attention. As a result, sometimes the ERISA cases fade away because they're important to us. They may be important to everybody else on a day-to-day sense, but they don't capture the public imagination for whatever reason that may be. There are only about 80 cases heard a year, and this year, up from 0 or 1, as we see in most years, probably 3 to 6 is what we're looking at. And some of them are fairly sophisticated in terms of the depth that they get to within the scope of ERISA, and some of them are pretty basic that you might have thought we would already have seen decided. Perhaps one of the things that we look at in terms of risk profiles is the statute of limitations. For those of you who don't deal in litigation, the statute of limitations is a rule that requires that if somebody is going to sue over something, they sue by a particular time. Normally, it's defined from a period of years from when the event that they want to sue about occurs. And ERISA has one that if you read statutes of limitations across various areas of law, this one is probably the most poorly written of all. It has a number of provisions that just don't seem to be fit together well. Instead, it seems like somebody took one idea from one statute, one idea from another, and threw them together, which is why one court has called it statute of limitations, it's held together by chewing gum and baling wire. We're only speaking today about a case that involves one aspect of that, and that is if a participant or beneficiary knows of an alleged violation, how long do they have to sue? And the answer is 3 years. But the question is, what is actual knowledge? And the case that's before the Supreme Court actually involves the type of 401k fee litigation that Brian was discussing earlier in the presentation. In this case, Soma, as the plaintiff pronounces his name, is somebody who was a regular visitor to the 401k portal at work. They could see that he downloaded certain information. They could see that he accessed summary plan descriptions, for example. And then Soma, after he's terminated, years later, turns up as a plaintiff in a 401k suit. When he is asked, despite having hit the website over 100 times in a 1 year or so employment tenure, whether he saw all of the disclosures that are on the website, he testifies he doesn't remember what he saw or whether he looked at them. There's no dispute that the fees were adequately disclosed. The only dispute is over whether or not the fees were reasonable and whether the fiduciaries had undertaken the appropriate steps to see that they're reasonable. So Soma's seeing this information is undisputed, but he says he doesn't know it. The Ninth Circuit held that that's not actual knowledge. You need to actually basically get Soma to admit he knew long before he brought the suit about this and he just didn't do anything. Not surprisingly, as the plaintiffs for Intel's investment policy committee argue, nobody's actually going to just admit that. And so what you're going to be faced with is a lot of people who just say, I don't know. And then effectively the 3-year statute of limitations goes away because somebody could always say, even if I read it, I didn't remember it. It presents a fairly interesting, for the lawyers on the seminar, fairly interesting distinction between what you actually know versus constructive knowledge. That seems to be one of the things that the Supreme Court is going to turn to in looking at what actual knowledge means in this particular circumstance. The takeaways for plan professionals is that when you think of the upside of the burden of making disclosures, it's to provide knowledge to the participants. And why do you want to provide knowledge to the participants? So they can take action if they believe it to be necessary. As a result, it doesn't feel right what the Ninth Circuit did, and that is, it doesn't feel right that if somebody follows the rule of disclosure, that there's not some benefit to them, and that is that this 3-year period begins when that disclosure is adequately made. That decision will probably be one that I think will go in favor of the committee, and I would expect that it'll come down between April and June of last year with a argument in late November or early December, most likely. Next, we move on to an issue standing relief and mootness are involved in. For those of you who are ERISA professionals and maybe not lawyers, standing relief and mootness often go to who has the right to bring a lawsuit, who is sufficiently aggrieved by the situation or damaged by the situation that they can sue, as opposed to just letting anyone sue about something that makes them unhappy. And in this case, it's a lawsuit by a participant who was a participant in a defined benefit plan. So they do not have a 401k account. They just have a right at the end of employment and the beginning of retirement to a stream of payments. The distinction is important for this case because in a 401k, you obviously have a right to what's in your account, but in a defined benefit plan, you really don't have a right to anything until you begin to pull the benefits down and you begin to receive those streams of payments. Here, the plan was underfunded. There was an allegation that there was poor fiduciary conduct, which resulted in a loss, and there was a lawsuit. Well, after the lawsuit, because they were close enough to being fully funded, somebody made the argument that we can go ahead and make a contribution to make us fully funded, and then these people have nothing to complain about. All of the money that an actuary would expect to be there to pay the benefits in the future is there. And if we do that, maybe the judge will say there are no damages and case dismissed. In fact, that's effectively what happened. So we have the Supreme Court faced with a question of, can a participant continue the lawsuit even though the plan is now fully funded? This happens more than you think, and if you think about a defined benefit plan and the impact that changes in interest rates can have on whether or not it's fully funded, you might not even need a contribution to change this. In other words, you could be 98% funded, 99% funded, and have either a market increase in the holdings of the plan or a change in the interest rate that's used to bring the plan to an overfunded status. At the same time, those things could work in reverse and move an overfunded plan to an underfunded plan. It does seem to me that this is a bit of an artificial way to determine whether or not a participant actually has standing. And to go back and tie in with the important non-monetary terms in 401k cases that Brian was talking about, a participant really doesn't just have a right to their benefit, but they also have a right to the idea that the fiduciaries are doing their job. And this case would leave you with the possibility that the fiduciaries could simply be totally imprudent or simply not do their job at all, and then just get bailed out by the plan sponsor by making an extra contribution whenever a claim arises. That doesn't seem to really feel good. So I think there's some force to the argument that the participants have here. And it may be a tough argument for a US bank to make before the Supreme Court to maintain position on this as the side that won at the lower court. So with this one, we're looking at a decision probably in March or June of 2020, this term of the Supreme Court. I know this is a case that's near and dear to Brian's heart, employer stock drop cases. A lot of this, what's involved in this case, runs across a lot of his experience in the ERISA area. When a stock drops precipitously, you can almost guarantee that security lawsuits will follow. Those are lawsuits brought on behalf of anyone who holds shares of the company on the public markets. Normally, the day after that, or sometimes on the same day, a lawsuit is also brought on behalf of ERISA plan participants if it is a plan in which the plan gives an offering of a company stock fund. So this isn't something where necessarily the stock that drops is just in a mutual fund or an index fund, but actually the employer's own fund within the ERISA plan. And these cases have been legion until a Supreme Court decision a couple of years ago called Duden Hoffer, which put a fairly high standard on bringing these claims. And after Duden Hoffer, there was almost an unbroken run of wins by the defendants, primarily because the idea was in a public market, all of the information is known. The ERISA fiduciaries do not have an obligation to break the law in what they are doing on behalf of an ERISA plan, and to the extent that they would take action on undisclosed information, they would arguably be acting as a securities law insider. And so really these cases on this issue represent the tension between the securities laws saying you can't act on information not known to the public, and the fiduciary obligation under ERISA saying that you have to act at the earliest practicable time. So IBM stock dropped precipitously and over some disclosures that the plaintiffs argue should have been made earlier. And they've then been sued both in a securities lawsuit and in an ERISA action that followed on the heels of it. In this case, the actual issue is not one that is really ERISA specific. In other words, the issue is litigation general. How specific must the participants be in making their allegations before the court? Do they have to say, here is a specific reason why you should have disclosed X, Y days before you did? Or can they just say something general like, eventual disclosure was inevitable, so you should have disclosed it earlier? The retirement plan probably has a leg up in this one. It's set to be argued on November 6th. That means with a case like this, you're probably going to see a decision between February and June of this term, which is 2020. Now, these three cases that we've talked about are ones that the Supreme Court has already said, we're interested, we're going to hear it, we want the lawyers to show up for an oral argument in Washington, D.C., and we're going to get to the bottom of this. There is another set of cases that they have where the losing side at the Court of Appeals level is urging the court to pick this case. The Supreme Court gets to select for most cases whether or not they want to hear it. And so you have to really explain to them why your case should be one of the 80 or so that they should hear every year out of the 8,000 or so petitions that they get. These last three that I'm going to talk about are in the stage of simply asking the court to hear them at this point. The first one, Putnam Investments, is one about causation. In other words, there may be a loss if you think about a securities lawsuit like the one that I just talked about with the retirement plan of IBM versus Jander, but the mere fact that there's a loss doesn't mean that the plan is liable. There has to be causation. There has to be a link between the fiduciary breach and the loss, and that's what causation is. In this case, there is a really, really nasty split among the Court of Appeals, the level of courts above the trial courts but below the Supreme Court, in terms of who has to prove that. Do the plan participants or beneficiaries have to come into court and prove this bad decision by the fiduciary caused this loss? Or does the fiduciary have to come in and argue that the loss was caused by something else, or at least not caused by their actions? The Supreme Court, as it often does in this area, is interested in whether or not the Department of Labor thinks this case is worthwhile. That's normally a sign that while it's not necessarily in the 80 that they're going to hear, it's moved from the greater pool of 8,000 into maybe the last 160 that they closely scrutinize to hear. And obviously they ask the Department of Labor's views on cases like this because the Department of Labor has investigatory authority and regulatory authority over ERISA plans. The next case is one that deals with ERISA's guarantee, alleged, of a purely federal framework for plans to worry about. For those of you, for example, who have job responsibilities that have you on the employment side and the benefit side of something, you know on the employment side, you're not only worried about federal law, but also state law. On the ERISA side, you normally are worried only about federal law with a few exceptions. That's because ERISA has one of the 3 or 4 broadest preemption provisions out of any federal law. And a preemption provision is one which says if a state law relates to the object of, in this case, ERISA, the state law cannot be applied. You only have to follow the federal law. Here, it's a lawsuit about the regulation of pharmacy benefit managers' drug reimbursement rates. Pharmacy benefit managers are people who sit between the pharmacies and the health plans and try to make their money by reimbursing the pharmacies as little as they can and charging the health plans as much as they can. So the spread is where their profit is. And these laws try to regulate how big that spread can be in part and provide, for example, an administrative process for people to challenge rates that they don't like. Obviously, if there are 50 different laws in 50 different states that affect pharmacy benefit managers, it makes life harder for them than if they just have to follow ERISA and look for regulations from the Department of Labor. In this case, you have an issue of whether or not the pharmacy benefit manager regulations relate to an ERISA plan, or are they just generic healthcare legislation that states are permitted to promulgate. And again, the Supreme Court is interested in the Department of Labor's views on this, which means that out of the cases that they're looking at, this one is a fairly good candidate. But again, the Supreme Court has not yet decided whether or not it wants to hear this case. If it does and Rutledge wins, that would mean pharmacy benefit managers are subject to the laws of 50 different states. If the Pharmaceutical Care Management Association wins, it would mean that you only have to follow ERISA with respect to this particular issue. The last case I'm going to talk about before handing it back to Brian is United Health Group Inc. versus Peterson. This is one that really involves out-of-network issues. So in network, there's a contract between the provider and United brings those providers and the rates set under those contracts to the health plans that it wants to be the administrator of and delivers those networks to those health plans. But there are obviously some areas where coverage isn't sufficient, or some people prefer out-of-network providers. So plans allow people with less generous benefits to go seek out-of-network providers. When that happens, United, if they've taken over the role of administrator, doesn't have a contract with them, so it can't try to set up the rules for their relationship directly. They just have to pay. Sometimes they pay too much, and when they figure that out, then they have to go back and try to get that money back. With their in-network providers, they have contracts that allow them to aggregate all of the claims for the in-network providers across all of the plans that the network providers are servicing ERISA plan participants that United is administering, and allows them to kind of balance all of those ledgers with overpayments being credited to the next month's bills, for example. Whereas with out-of-network providers, they don't have that ability. That means that they have to go back on an individual basis, claim by claim, and try to get the money back provider by provider. United didn't like that, so it started to argue that the ERISA plans allow them to do it. And most plans, not surprisingly, are simply silent on that because they're not drafted with United's problem in mind. United is really an administrator's problem, not a plan sponsor's problem. So in this case, they're trying to argue that if the plan document is silent, it's left to the administrator's discretion whether or not this can be done. Well, who's the administrator? United. What do you think they're going to do? They're going to say, of course you can do it. And so what this really is an administrator's ability to try to get their arms around the problems of out-of-network providers specifically. This is a claim that I think out of the three that we've talked about is least likely to be granted. So in other words, it is most likely to stay in the current situation where United Health lost below and was not allowed to engage in cross-plan offsetting. But again, out of the 8,000 petitions that the court gets every year, this one might not be in the top or second tier, but it's in the tier of having sufficient gravitas that it's going to get a close look and it could be granted. At that, I'll turn back to Brian for questions and our wrap up.
Okay, great. We do have a couple questions here. The first one is someone is asking for our views on if arbitration is, assuming arbitration is an option for a plan fiduciary, is it a good idea? And I do actually have a strong point of view on this, and Tim, I'll be interested to hear what you have to say as well. I'll start with my perspective on this. It goes beyond ERISA, just to all arbitration clauses. I remember one thing from law school. It was the professor who had represented Major League Baseball in the Andy Messersmith free agency arbitration in the 1970s. That's not when I was in law school, but that's when he was a lawyer. And he lost that arbitration, and it changed Major League Baseball forever. It changed the business model. It made players less beholden to their original team, and they had the right to move around, and then salaries skyrocketed thereafter. But this professor almost had tears in his eyes as he was saying, remember this always. Never agree to arbitrate anything that really matters. And I still remember all these years later, nothing else from law school except that, because he was so emotional about it. And if you think about it, the best time to use arbitration clauses are when you have lots of little transactions where some things are going to go wrong and you need a mechanism to handle the disputes. And arbitration can be more cost effective and speedy. And it doesn't really matter whether you win or lose this case or that case. Overall, what you need is an efficient mechanism for dealing with disputes. So, for example, broker dealers really benefit from having arbitration clauses because they have lots of customers, and inevitably they'll have a certain number of disputes. And rather than be in court for all of them, they arbitrate. And no one dispute is going to ever threaten the business as a going concern. So it's okay to arbitrate those. But like take a big M&A transaction, usually those transactions are bet the company, and they do not include arbitration clauses, because if something goes wrong, people want their dispute heard by a judge, and they want to have the right to appeal. That is the biggest downside of arbitration, is the loser has no right of appeal. There's only a tiny little window to argue, to vacate the ruling. It's much harder to do that than to win an actual appeal. So my big picture perspective is arbitration is good if you have lots of little disputes, but it's bad if you have something that threatens something that really matters. So, for example, all those fee cases we were just looking at, look at the dollar amounts, look at the entanglements with the plaintiff's lawyers for years to come. Those are serious matters, and I wouldn't want them being decided by an arbitrator where I had no right of appeal. So if a claim affects the whole plan, multi-million-dollar claim affecting the whole plan, I wouldn't want to arbitrate it. An obvious exception in the ERISA context is like maybe individual claims for benefits, or in the health and welfare side, arbitrating certain kind of claims disputes could be fine. They tend to be smaller in scope. But if you're talking about fiduciary duty claims, where one participant can sue to restore losses to the entire plan, I just do not think arbitration is an attractive option. The only footnote is what Charles Schwab just did when they not only enforced an arbitration clause, but they convinced the court to say that the participant could only bring their arbitration claim to restore their own losses rather than the losses of the plan. So in effect, they made it a small dispute, which I think could be handled in arbitration. But if that one participant actually has the ability to bring a multi-million-dollar claim for the whole plan, the last place I would want to be is in front of an arbitrator who has nobody looking over his or her shoulder, who wasn't appointed by a president, it wasn't vetted by the Senate. If you think about it, ERISA has many, many advantages that were crafted on purpose to be in favor of the employer. No extra contractual damages, no jury trial, preemption of state law claims. There's a lot of good reasons you want your ERISA claims against you to be heard in federal court. Why you would want to jump into arbitration and out of that protected area, it boggles the mind. But there are still people who love arbitration and try to make it happen. Tim, do you have a perspective on this question?
I agree with yours. The other key reason for me is expertise. This is an area that those of us on the webinar know well and our colleagues know well, but it is not an area where I see many qualified arbitrators available. So my practice stretches between ERISA litigation and employment litigation. There are a lot of arbitrators in the employment field, and even those that aren't in the employment field can pretty much pick up an employment claim and understand it and understand kind of the rubric within which employment laws arise and give you somewhat of a rational decision. The gap between arbitrator expertise and federal judge expertise, even at the trial court level before you get to an appeal, is vast. So you could get a bad judge. That's why Brian's point about the appeal is important. But even the bad judges, maybe ones that have a bias for participants or beneficiaries as opposed to plans, understand the outer limits and the general feel of how ERISA works. And I think whether or not they might have a bent one way or another, they are trying to do the best that they believe is appropriate. With arbitrators, you don't know what you're going to get. And so the more complex or within the weeds in ERISA of a claim that you have, the least I would want it to be there, just because I would trust a random federal judge than a random arbitrator.
Great. Thank you, Tim. We have time for one last question, a short question and answer. What can we learn from the few ERISA cases that actually go to trial? And I have a pretty strong observation from the NYU case and the American Century cases that went to trial and were defense victories. It reinforced the importance of meeting minutes, a hyper boring topic, which all of a sudden the meeting minutes of those fiduciary committees become the star witness at trial. And so if there's one thing I could pass along to everybody, if you play any role in organizing committees or advising them or participating or serving on one, picture your meeting minutes being entered as an exhibit in federal court and being asked questions about who prepared them, when were they prepared in relation to the meeting, what wasn't included in the minutes, why did you use this word and not that word, and be prepared for the argument the plaintiff's lawyers make. If it's not in the minutes, it didn't happen. So I just passed that nugget along to everybody. Meeting minutes are really exposed to public viewing if a case goes to trial. So with that,